Hi everyone, Dave Sugden of Evidence at Trial. We're talking about the admissibility of social media evidence. And this is in fact our third and final video in a three-part series. So if you haven't seen videos 1 and 2, I suggest going there now because it will give more context to make this video make more sense. But very briefly, where we've been so far is we've talked about social media evidence. In other words, what type of evidence is it? We then talk about looking at the relevance of evidence. We then talked about how to lay a foundation for evidence. And now we're going to talk about a couple important cases you should know when it comes to looking at the admissibility specifically of social media evidence. And then we'll round out the method for analyzing social media evidence. The first case we're going to talk about is a case called People versus Valdez. Now, this was a criminal case where there was a defendant, Mr. Valdez, who was arrested and accused of attempted murder. And in terms of his sentence, it was going to be enhanced if the prosecutor could show that it was a gang-related crime. And so to do so, what the prosecutor tried to do was introduce information from Mr. Valdez's MySpace page. And they called an investigator, and this investigator, in essence, testified that prior to these crimes, he would go on MySpace to look at gang-related activity. And he had a bunch of pages pulled from what appeared to be Mr. Valdez's MySpace page. And it included photographs that showed gang-related activity. It showed a bunch of sayings that indicated gang-related activity. It also included Mr. Valdez's interests. And this is, no joke, what he identified. That he enjoyed mobbing the streets and hustling. He also enjoyed chilling with homies as well as spending time with his mom. It sure did. Now, when it came to trial, Mr. Valdez's lawyers argued none of this should be admitted. And the reason why is because Mr. Valdez presumably didn't testify because of his Fifth Amendment right. And the investigator was examined as to how did you find these MySpace pages and how do you know they belong to Mr. Valdez? And the investigator said, well, I basically went online and I understand how MySpace works, where you need a username, you need a password, and unless you have those two things, you can't upload information. And all these photos, they're of Mr. Valdez. All of these things, it appears that Mr. Valdez created this page. But then he was asked on cross-examination, well, do you know if he did? In fact, do you know if he has other people that had access to the page? Do you know who actually uploaded the photos? And the investigator knew none of this. And yet, all of the MySpace page was admitted into evidence. It then goes up on appeal, and among the things Mr. Valdez appealed was this wasn't fair. It should not have been admitted because there was no evidence showing that Mr. Valdez created this page. What the court did is it affirmed the conviction. And it affirmed the conviction saying that the authentication was sufficient. And again, going back to the rules we talked about in video 2, we see that you don't need Mr. Valdez's testimony. You don't need a witness to attest that I'm the one that uploaded this information. So often when it comes to issues of authentication, lawyers think that if it's a letter, you need the author. If it's a photo, you need the photographer. You don't. In fact, specifically in section 1411, it says you don't need the author. And in section 1410, what the evidence code in California says is we're going to provide a number of examples as to how to authenticate evidence. And what 1400 says is, by the way, all these examples, they're not exclusive. There can be a number of ways to authenticate a writing. And one of the examples they identify is found in section 1421. And that says you can authenticate a writing based on its contents. In other words, if you have content that appears that only the person that you believe is the proponent of the writing, the person that created, if he's the most reasonably likely person to have created that, that can also be a way to authenticate a writing. And so what the appellate court did in Valdez is, in essence, regurgitate what the evidence code says. And it says just because a judge has admitted a document and said that there's been a sufficient foundation, it doesn't mean the judge believes it's authentic. What it believes is there's been a sufficient showing to support a jury finding. And the court said, Mr. Valdez, he was free to provide evidence that denied that and create a factual dispute. But again, that goes to the weight of the evidence, not the admissibility. The trial court got it right, and it was authentic. And the conviction was affirmed. Another case we need to understand is In Re KB. This was another criminal case. And in this case, there was an investigator that was on Instagram, and he was looking at a bunch of pictures, and he saw these pictures in an apartment and saw a picture of the defendant holding a gun. And the investigator knew this defendant, and this defendant was on probation. He wasn't allowed to be having guns. And so he was obviously concerned that this defendant is posting, or appeared to be posting, photographs on Instagram with a gun. He then calls the police and says, you need to arrest this person. He's now violated his probation, and the cops show up. And when the cops show up, he's in an apartment very similar, doesn't have a gun, but he's wearing clothes that match the picture where he is holding a gun. And very similar to the Valdez case, this investigator was called to trial, and he was asked to authenticate these pictures. And he explained, well, this is how I understand Instagram works. I saw these pictures. It looks like the defendant, he was holding a gun. And then when the police show up, the apartment matches the photo, the clothes match. We believe this was him holding a gun, violating the probation rules. Again, the defendant said that should not have been allowed, that there wasn't an adequate foundation because the prosecution never called anyone who took the picture, who uploaded the picture, anyone with firsthand knowledge. And again, like in Valdez, the court said, no, that the burden is too high in terms of what you're asking for. All you have to do is provide a sufficient showing. You have to, as the proponent of the evidence, you have to provide evidence sufficient to support a finding. And what the court says is that can be proven, like any fact in a case, by circumstantial evidence. And so the fact that this investigator saw this photograph that matched what the defendant looked like, and in a room that appeared to be the same room he was in, that was circumstantial evidence that we have an authentic photograph, and the conviction was upheld. And so again, when it comes to authentication, not just of evidence, but social media evidence, it's not overly complicated. And if we remember the rules, 1400 in California, 901 in the federal rules. In fact, 901, similar to the language we see in this is actually evidence 1410, where it talks about this list is not exclusive. Under Rule 901, it provides a list of ways that a writing, document, or recording can be authenticated. And what it says in 901 is this list isn't complete. In other words, there's a number of ways that a proponent of a document, a photograph, a recording can provide information sufficient to support a finding that it is what the proponent claims it to be. So, with foundation out of the way, what do we do with social media evidence? And what we do is the same thing we do with any piece of evidence. We then analyze whether there are any hearsay rules. And again, look at other videos or other resources at Evidence at Trial to learn about how to spot hearsay and spot the hearsay exceptions. You'll then want to consider exclusions and limitations. When we're talking about social media, there can be issues of privacy that we want to consider. Character evidence. There's another video on character evidence you're going to want to see. And then finally, prejudice. In other words, is this relevant evidence? Is it being substantially outweighed by some prejudice? This method is the same method we take when we're talking about any piece of evidence, including social media evidence. So that is social media evidence, and I hope this was helpful. If you enjoyed this, please rate, review, leave a comment, subscribe to our YouTube channel, and check out evidenceattrial.com. We have a list of online courses where you can do a deep dive on the issues we've talked about to make sure you understand these rules of evidence and learn how to make them weapons of persuasion at your next trial. Thanks for watching.